seated, please. Good afternoon, everyone. Thank you for coming. We have one case on the docket this afternoon. Ken Paxton, Attorney General of Texas versus Delia Garza, Travis County Attorney et al. Who's present for the, let me see, are we appellant? Yes. Who's present for appellant? And for our respondent, or appellee?
Brad Sneed and Justin Piper.
Good. And 15 and 5?
Yes, Your Honor.
All right. Anything else? You may proceed.
Thank you, Mr. Chief Justice, and may it please the court. For more than nearly 150 years, the legislature has empowered the Attorney General to obtain reports from district and county attorneys related to criminal matters in the interest of the state. Pursuant to his express statutory authority to direct the time and the form of those reports, earlier this year, the Attorney General promulgated a series of regulations designed to inject order and predictability to this otherwise ad hoc reporting process. The trial court erred in temporarily enjoining the enforcement of those rules because plaintiffs lack
This was to enhance what and what? Organization or predictability?
So the rules certainly provide predictability and order to the otherwise ad hoc process there. Now the trial court, we believe, erred in temporarily enjoining the enforcement of these rules because plaintiffs lacked a probable right to relief on their claims for 4 reasons. The first being that the reporting statute, that is Government Code 41.006, provides the Attorney General with implied, if not express, rulemaking authority. Second, the rules come within the broad ambit of the statute's scope. They don't exceed it. Third, there's no Administrative Procedure Act violation. And fourth, the rules are consistent with the Separation of Powers Clause.
Before you get too far down the road, are you aware of any case law where there's been an implied right to make rules where there's not already an express right to make rules?
So the closest case that I'd point you to is Pruitt. Now there was subsection 4 of the statute did have a sort of express piece, and there was a dispute in that case about whether or not that applied there. So the court was looking at subsection 3 of the statute, which said that the Harris County Bail Bond Board could supervise and regulate the bonding process. And the court there seemed to suggest that it was implied in that case from that broad grant that there was rulemaking authority. And we think the same is true here. We think the statute in that case was actually broader than the statute here. But at a minimum, we think in terms of the implied authority, what we see is that the statute here gives the Attorney General the express power to obtain these reports. And it's at least fairly implied that he has the authority to promulgate rules to obtain the information.
But
Textual clues abound on
But
that.
in Pruitt, there was express rulemaking power. So is it consistent with that to say that if you're going to have implied powers, you've got to have express first?
I don't think the court said that in Pruitt, and so that's not how we read it. Again, subsection 4, the court sort of set that to the side in the portion of the analysis that we're pointing to. But I think if you look at, I'm happy to talk about the express point now before I get to the implied. We think it's expressed from a couple of textual clues in the statute. First, I'd point you to directs, the time and the form of the report. We think the plain meaning of the word directs is a formal, sort of mandatory obligation. The other portion and the other half of the statute that we point to is that it says that they shall report information that the Attorney General desires. Now that seems to vest authority in the Attorney General to desire the information, but also certainly to communicate that desire to the district and county attorneys who are subject to the obligation.
Can you tell us a bit about how this process worked before the rulemaking?
How the reporting process?
Yeah.
I don't think there's anything in the record that suggests that discusses the process before then, but let me, if I can, I think go to the heart of your question, which is, and I don't think my friends on the other side quite get there and suggest, well, this statute is old and it hasn't been used in this way so far as we can tell, so you really shouldn't enforce it. That is essentially an argument from desuetude, but it would violate the canon against desuetude to say we can't interpret the statute in this way because it's old. Now, we do think focusing on the text of the statute supplies the answer that you need as to both its scope and the rulemaking authority question. But There isn't anything in the record that suggests how prior attorneys general used it. I don't think certainly this attorney general hasn't used it in this way before.
Are you aware of any case law where the word direct or any of the words that are in 41.06 are used to confer express rulemaking power?
I'm not aware of a case that explores that. We think it certainly follows from the plain meaning of the word direct. I mean, my friend on the other side's response is, well, that direct is essentially precatory, it's optional. It essentially means it's a helpful guidance. I think that would not cohere with the statute, what the statute says, which is that it's making it mandatory. Certainly in the context, we think the plain meaning of the language is mandatory. There's not a case, Justice Field, that I'm aware that explicates that. I grant you it's an older statute, and it certainly seems, but have to acknowledge that the convention is more now to say rulemaking authority rules, but I don't think that precludes the existence of rulemaking authority here. And I'm certainly not aware of a case that essentially says you got to use these rules, legislature, these linguistic convention legislature, or there is no rulemaking authority.
Yeah, I was really wanting to explore, Professor Beal filed a couple of amicus briefs, been teaching admin law forever, and he claims in his amicus brief that this is one of those times where magic words really are required. You never get to respond to amicus briefs as lawyer, so giving you the opportunity, what's the response to that?
Sure, happy to do so. The Supreme Court said there was no magic words requirement in SC. My friends on the other side don't really dispute that either. So I don't think there's any reason for the court to import a magic words requirement. Ultimately, the obligation of the court is to fairly interpret the text as the legislature passed it. And we think the text leads to not this magic words requirement, but a formal rulemaking requirement. Surely, at the end of the day, it seems like my friends on the other side would have no problem, at least with regard to rulemaking power, if we put these rules in a letter and sent it to them 30 days before and said, here's your obligations. Sure, they would probably have other questions about that with respect to the other issues, but it seems to me, and I'm sure they'll correct me if I'm wrong, that they would have no obligation in principle to us putting it in a letter. I mean, these rules set them out in advance. They provide notice about what's going to be required. So it seems to me it's it's a process that's better.
So you're in the executive department,
Yes,
and the county and district attorneys are in the judicial department.
the Constitution says that, yes.
Yes, and so is there a problem with your department telling their department what to do? I mean, I think the legislature can do that. They just did with the district judges. I would argue that what the district judges are required to do is much more intrusive than anything they're asking you to do here. You got to account for every hour of every day of every year. There's no question the legislature can do that. We don't have the legislature doing that here, so how can the executive department, one part of the executive department, take up the baton?
Well, because we're acting pursuant to a statute passed by the legislature, that's section 41.006. Now, we could talk about whether or not the rules comport with that statute, but certainly we're operating in this case not pursuant to some sort of ethereal power, executive branch power to compel information, but pursuant to a statute the legislature passed and recodified in 1985. So I don't think there's a separation of powers clause problem here on that point with us just, with the mere fact of us taking advantage of what the legislature has, the tools the legislature has given us.
How about the power to file a quo warranto and remove?
That's an existing power under Chapter 66 of the Government Code, and no, there's no power there.
Well, except it's not. I mean, Chapter 66 lists things you can file quo warranto for, and violating rules passed by the AG isn't one of them.
So the question about whether that would be a ground for quo warranto is a separate question than I took the Chief Justice's initial question to be, can you do this? I'll take those in turn. Yes, we can do it. Chapter 66 gives us the power. Whether or not that would constitute a ground for quo warranto is, in our view, something that would be litigated at a later date if that ever came up. A couple words about the quo warranto provision there. First, that's 56.8. It's a remedial provision. It says the Attorney General may do this, which implies that the Attorney General may not do this. We don't think they have standing to challenge that because the Attorney General has a variety of options under the statute to secure compliance, including an ultra vires action, including notice. So it's not clear that the Attorney General would rely in a given case on the quo warranto power. The second thing, again, is that it's referring back to pre-existing power under Chapter 66. I take your point that we would have to litigate at a later date whether a rules challenge can suffice as a ground for quo warranto. But I think that's something the court needs to grapple with here because that's a down-the-road problem. And the last thing is, if you're not convinced with either of those 2 points, the last thing is it's severable. 56.10 indicates that remedial provision is severable. Remedies are the classic thing that's severable, and it's somewhat of a red herring from the larger piece of the statute here, which is the information gathering requirement.
So y'all, one position I caught in there is you're basically arguing it's not ripe because we're not trying to remove anyone. It's, to the extent that's a separation of powers issue, we don't get there. Is that just want to make sure I'm understanding?
Yes, that's right. We don't think it's a separation of powers issue. I'm not sure that they've said it's a separation of powers issue. To the extent they are, again, we're relying on Chapter 66, which the Supreme Court just construed in Enunciation House versus Paxton with an area suggestion that there was a separation of powers clause problem. We don't think there would be. At common law, it was common, let's say, common at common law for the Attorney General to prosecute these actions on behalf of the King. I don't want to drag you too much into the quo warranto dispute. There's a case that the Supreme Court may decide at some point in the next few months about the scope of that power. But suffice it to say that that power is, under Chapter 66, is extant. There's no separation of powers clause violation there. On sticking with the separation of powers clause point for a moment, I took my friends on the other side argument to be a little different, and that is that these rules somehow give us power to superintend prosecutors. I think they went so far as saying that we can collaterally attack judgments. And on that point for a second, there's nothing in the rules that gives us that power. This is merely an information gathering requirement. And so I think where their argument cashes out is they're saying, well, this imposes a burden on us. And the burden is, in their view, too great. And so that means it's a separation of powers clause violation. That's not what we think the Supreme Court said in Webster and in Ray House as the test for a separation of powers clause violation. That test is whether the exercise of power by one branch impairs or impedes or negates the core powers of another branch. Their core powers are, of course, prosecution, but nothing in the statute prevents them from prosecuting cases.
Your brief said everybody but the parties to this case has filed their initial report.
That's correct.
How many is that?
It's something on the order of 6 or 7, I believe.
Because there's, my rough count on Google, there's 14 counties that this applies to.
Yes, that's right. Mm-hmm.
And so the rest of them,
Our parties-
we don't care what they do, or what's?
No, but to the contrary, the rules say, and this is spelled out there at, I believe, page 2174 of the volume 50 of the Texas Register, the Attorney General's view is that these largest counties, it's of course a population requirement, are more indicative of trends in the state than all the other smaller counties. And so I think that makes good sense if we're looking at that from, say, an APA reason justification type requirement. The places where the volume of crime is the highest, where the volume of people is the highest, where the volume of prosecutions are the highest, would be more indicative of sort of trends in the state. At a minimum, at a bare minimum, that's a rational thing for the Attorney General to conclude. And so I think you were sort of getting at the APA
And
point.
does remind me, once the rules are adopted, does the legislature have an opportunity to revoke or repeal or do anything with the rules?
The legislature could always repeal the statute that it's based upon, sure.
Or modify it?
Or modify, they could always do that, sure. And I think that gets to an important point, if I might, Mr. Chief Justice, which is that a lot of the tenor of the argument is that these rules are burdensome, they're logistically and fiscally improbable. Well, the legislature can always step in. If it really is that great, the legislature can correct course, if indeed the Attorney General is, in their view, exceeding the statutory warrant.
Well, I'm more concerned that, if we get into something where one party does this when they're in power and the other does the other. I mean, I'm just looking at the first two. I would not have thought the first two things you wanted to know were how many peace officers have been indicted in their official duties, and number two, how many people you've indicted for election code violations. I mean, I wasn't there, but I assume this means we want to know which of you counties are enforcing things strictly against police but not against election law scofflaws. Now, what if we switch that around and we say, and we get a different administration in, and they want to know counties where they're prosecuting people for carrying for carrying a gun without a license, and they don't care, but election laws, oh, they're going after those with a vengeance. It'd be interesting to know if counties are doing that, and I think I concede that would be a problem if that's what we're having in black and red and blue counties. But where is that going to end if we just, we amend these every few years to try to rein in district attorneys we don't like?
Well, the statute itself provides that the Attorney General can request the information he desires. It rests within the discretion of the Attorney General. Again, it's just information. He's asking for information, and the 2 points you point to are really essentially prosecution statistics. And so the
Do they exist already?
Do they exist already? There's been some discussion that maybe some version of them exists in the administrative court system, but I think that these ones don't. And if they do, then it's pretty easy for them to come up with.
Put it together.
Yeah, exactly.
Anything further? Thank you very much. And do I see here that you wanted to split your time, Mr. Sneed?
Yes, Your Honor. I'm here on behalf of the appellees, except for Mr. Pfeiffer will do 2 minutes on behalf of Mr. Middleton, appellee Middleton.
So watch the light, because I'm not.
I think they've set me up with 18 minutes,
All
here,
right.
so I think I'm good. May it please the court. I'd like to focus on rulemaking, the meaning of the statute generally, and how broad we should interpret it. And then third, time permitting, a quick separations of powers point that I think follows up on what Justice Brisser said. On rulemaking, Justice Field, no court has ever implied the power to rulemake itself. Yes, you need an express grant first. But I do want to say this as far as the standard, and I think we get bogged down in this express versus implied. I don't think it matters. The standard is no reasonable doubt. The case law says even if you imply authority, not out of necessity or not out of expedience, not because of an agency's own views, which I think is what we're hearing, it has to be obvious that that's what the legislature intended. And State versus Holland says if there's any reasonable doubt must be resolved against implied authority.
Well, if you ever were going to find true implied authority without some type of express regime, I mean, this is one of the broadest statutes that I've seen. Shall report to the Attorney General the information that the Attorney General desires. I mean, those are big concepts, big words. So there could never be an implied, I mean, if this doesn't get us there, then basically that door's shut, right?
Yes, and 2 points on that.
Okay.
One, I think conceptually, like, rulemaking is an extraordinary power.
Yes.
And to say we're going to imply an extraordinary power subsumed in a modest information power just doesn't make any sense. But I think what you're getting to is what my second point is what's the scope of this?
Now, what does this mean if not
What does this
rulemaking?
mean? Can they get this information anyway? Like there was a comment about, well, we can just send them a letter. They wouldn't have a problem with that. Yes, we would. Here's my answer to those line of questions. Either the statute is narrow, read in context, or it is unconstitutionally broad, read in isolation. I'm going to repeat it. It's either narrow, read in context, or it's unconstitutionally broad, read in isolation.
So the narrow context is you have to have some good reason to ask for the case files?
The narrow context is the historical context, right? And that's, we have our bench exhibits, we don't need to go through them, but that's what we have as the context. Exhibit B is the historical context, which is what the case law says we have to start with. A statute's meaning is fixed at the time of enactment, so what it means then is what it means now.
So what did it mean then? What did it mean in
so
1879?
Our view in the context is it's a helper statute, a helper provision that points to the governor reporting, tethered to the governor reporting constitutional provision in the statute. In Exhibit B, we have how it laid out originally. Constitution granted the governor this authority. Then the statute's implemented. Article 29 is governor to AG. 30 is AG.
So when we remove the governor reporting, the purpose for this statute disappeared.
Well, we haven't removed the governor reporting. If you look at, so we have 2 pages on the exhibit. The second page is how it is today. It's exact same, just not Article 30. That was repealed. That was the kind of the narrow grant of authority between the AG and the prosecutors. There's an argument that that orphaned the statute. I don't think it matters. It's the same. It's the same today. It's still the only context. If you read it in context, it is still pointing to government reporting. And I think in practice.
So when does it apply specifically?
So I think in practice, it may not apply. It may not be doing any work. The Constitution still has this governor reporting statute, and so we would say that it still applies when you're pointing to the governor.
Okay,
Right?
I got that argument, but
Okay.
let's assume for argument that I don't believe it.
Okay.
So we've got one that says, it doesn't say they'll respond, it says they will report. It doesn't say they'll respond to a request, it's that they'll report because they know he desires it. I agree, that's pretty broad. So let's assume that included when he wants, maybe for a habeas appeal in federal court or something, he wants Attorney General wants some information, requests it, sent the case file, et cetera, et cetera. Assume that's okay. Then can you do it twice? And can you ask for 4 cases? And can you ask for 10? I can see why you don't want to agree one letter in one case is enough, because then where does it stop?
I think I understand the question. Is the question what happens if the governor starts asking?
When is it no longer, you can't send a generic request to everybody or one to each county?
Yeah. So
But
here's
how many cases, files do you have to be requesting and before you got to go through rulemaking?
Well, I think this is the other part of my answer. Is that I don't think that it's hard to find a middle ground here, right? It's fine. Like, what is it? Like, how much information is on this line? You know, we define information as knowledge, but they define it as saying anything in case files. Like, it's hard to find a middle ground. But here's where the other part of what I said unconstitutionally broad, because they look at it in isolation, like anything the AG desires. And let's say it's anything the governor desires, and the AG, well, sorry, take that back. Anything the AG desires. The legislature can't give the AG a blank check. It's a non-delegation problem, which we brief on page 63. The proper delegation is a legislative policy, and you delegate a specific power to implement legislative policy. Here, there is no legislative policy. If you look at it in isolation and divorce it from the rest of the statute, there's no legislative policy whatsoever. It's just what the AG desires. And I think the best case is Abbott versus Harris County. The court was confronted with a disaster act and a mask prohibition order. And the statute, and the provision was the one they looked at, 418.012 of the Governor Code. And it basically said the governor can issue orders that have the force of law, period. And the Texas Supreme Court looked at that and said, that's dangerously close to non-delegation. We don't want to have to deal with that. And it said, we're going to look down in the statute later when it said the governor has the power to control ingress and egress. And so it said, okay, we're going to look at that as the authority. We don't have that here. All we have is that single sentence. And if it is as broad as they say it is, and it's hard to argue about that if it's in isolation, it runs in the same problem that the Texas Supreme Court avoided in Abbott versus Harris County. A couple other points before getting to separation of powers. They talk about the word direct. Exhibit C is a more modern reporting statute. It's vis-a-vis the OCA, and it says as the manner and form prescribed by the Attorney General, and then it has a separate rulemaking provision. We think that's a good example of a couple things. One, what does direct mean? Well, it's prescribe, and Article 30, by the way, has prescribe and determine. Those are synonyms. We think direct means direct or something like that. Not regulate, not shall adopt regulations. So I think Exhibit C is a good example, and it's a good example of when the legislature has a reporting requirement, it knows how to have rulemaking if it wants to. And they had 150 years to add that to the statute if that's what the intent was. They haven't done that. In their reply brief, just one more point on rulemaking. They argue, well, modern rulemaking didn't exist then, so we should, I think, have a looser standard. I think the obvious answer is the opposite one. If their modern rulemaking did not exist then, we can't imply that's what the legislature intended. But also, I want to point the court to a couple provisions that were contemporaneous that had similar language. Article 228 of the Code of Criminal Procedure says the municipalities may establish municipal rules. Article 4582 of the 1895 Code, Revised Civil Statutes, after the Railroad Commission was enacted, said the commission shall have the same power to make and prescribe such rules and regulations. This is all contemporaneous with the statute. The legislature knew what it was doing then. If it wanted to use these words, it could have.
You can always, in hindsight, make a statute clearer, 100% of the time. So the question is, this is the text we got to work with. So I've got that argument, but
Well,
if that was the rule, every vague statute would be unenforceable. You could have made it better.
I'm not going to argue with you on that one. But I think on the breadth of the statute, regardless if it's narrow, like we say, like it's helper statute, or if it's unconstitutionally broad, it still doesn't do rulemaking, right? So and in my view, those are two issues that get conflated a little bit.
And that's all we have to decide here, right?
Well, to affirm, all you need to do is decide there's no rulemaking, end of story, affirm, go back down. If you're going to go against us,
Then
you
we
have a
do
lot more
have
work
to,
to do.
yes.
So, the people across the street, they've got a bigger hammer than we got. They do what they want to do. And if we say there's no rulemaking, what happens in the next session when they pass a rule saying the Attorney General can make any rules for county and district attorneys he wants? Is that going to help you? Are your clients going to be happy with you and that outcome?
Well, let's talk about the third point, separation of powers. There's several different version or specific arguments made in the briefing, but I think one at a structural level is what you were getting at. This is rulemaking across the horizontal separation to the judicial department, and also the vertical separation into constitutional officers with exclusive authority. And the case law says within their purview, county and district attorneys have the same authority, same judgment and discretion that the Attorney General does. Right? And the Constitution grants rulemaking to different departments internally, with a few exceptions to the legislature for the judicial department. But we would argue that's an rulemaking itself. Besides interference, besides that, rulemaking itself is a constitutional power that's given to constitutional officers, departments, and that they can't rulemake over us, just like we can't rulemake over them. And I think that also is a through line here. If you look at the exhibits C and D, there's three different provisions. One is it's reporting vis-a-vis the OCA, and it has rulemaking. And the OCA is a legislative body that's housed in the judicial department for the purpose of information sharing. Two of the provisions are directly against prosecutors. No rulemaking. Right? I think that's a through line, is that the legislature is respecting these vertical separation of powers. And so I think I'm not asking the court to rule on this, but it's another reason why we should have a narrow reading of the statute. It runs into non-delegation, it runs into separation of powers. The obvious, what does this mean? It doesn't mean rulemaking, but it's a narrow helper statute.
So this is not a new problem. The problem with local enforcement of justice is it varies from place to place. 100 years ago, there were counties that would not protect African Americans. They would not protect their right to vote. They would not protect them from harm from people that hated them. And so we got a federal statute, the Ku Klux Klan statute, that says, okay, we'll send the feds in and we'll fix that. And that's what I'm concerned here. I mean, we've had several cases already on the places that say, as a policy, we are not enforcing marijuana laws. And so the lawyer just comes back and says, you can't have that policy. And they say, we're going to have it anyway. And they come to us and we have to tell them, no, you will go to jail at some point. So now, how far down this road are we gonna go when the harm to you is, if it's in a big county, you get a few people together, you pull this electronic information in and you send it in. That, I agree, the harm could come if then the Attorney General starts kicking people out of office that are locally elected. I'm concerned about that, but as you say, I think we can worry about that another day. But I am worried about an overreaction. Some people would say it would be a normal reaction to the fact that some prosecutors, as a policy, will not enforce some criminal laws. Just won't. You disagree with that?
I am not taking any position on that.
I bet you would. Might be contrary to your clients. That's the problem. So who's going to do something about it?
The people.
The elected, who elected them and passed the initiative referendum saying, we're not going to enforce.
Right. Look, is there any avenue for the legislature in this problem? I'm not going to speak to that, and we'll deal with that another day. I do want to address, though, the harm. There's obviously the threat of removal.
Right.
We don't think, just generally speaking, that they have the quo warranto powers they claim, but that's a different argument altogether. The APA allows enforcement, right? Direct enforcement. You don't even need that provision to have a problem. It's enforcement. Any violation of this can be an enforcement. And it's the idea that it's just information. I want to point the court to the 56.36. This is of the challenge rules. It's any case file, including cases where there are substantial doubts by the Oversight Advisory Committee whether probable cause exists to support a prosecution. They are going beyond just statistical information and wanting to review the, I would argue, from Webster, constitutionally privileged judgment and discretion of county and district attorneys, invading the candor and the case file, and that is explicit. And it's an independent committee who has their own power. And exactly, they're vague on exactly how they're going to do all this. The preamble says the goal is to enforce the rules, or to enforce compliance. Sometimes when someone tells you who they are, you believe them. And besides that, the AG waves its hands at just a couple more employees. And there's unchallenged findings below. They had the opportunity to put on some evidence. They didn't do anything, right? There's Dallas County had presented evidence that it would be 22+ million over the next 5 years. And all the counties had it cost millions, and 5 to 10 employees and outside vendor services. So these are real harms. Unless there's any other questions.
Well, pay
Can
no
I-
attention to that light. I took an inordinate amount of your time, so my colleagues may want to get a question.
I'm here as long as I
before
get
you
to
leave.
save 2 minutes from my colleague. I'm here as long as the court has questions.
I'm not counting this against you or your colleague.
So I just want to, I guess, focus in on one question. Are you arguing a separation of powers violation based on the extensiveness of the reporting obligation, kind of in addition to the other theories? Like if, let's say, they were only asking for statistics, separation of powers violation, yes or no?
Right. I think if you could do
Right.
separation of powers quickly, it'd be structurally, like I talked
Right,
about
the
earlier.
rulemaking.
And then
right.
there's Webster invasion into the constitutionally privileged.
Sure.
And then there's third is interference. And that would be interference, I think, and interference in fact. And
that's
this
a
is-
degree.
What?
And that last one turns on the degree.
I
right?
think so, and this is a unique situation where, like in Meschel versus State, we're forcing prosecutors to go faster. That's kind of like an objective look. Here, we have an unchallenged finding that it will cause victims and witnesses not to cooperate and not wanting to have full disclosure. And so I think it's a finding on interference in fact, and so that would be the third separation of powers argument. And if the court gets there, I would suggest that it should defer to the trial court's finding on that.
Well, one question on that. You just raised a question for me. Because we're here on a TI, we're under abuse of discretion. We have an evidentiary record that's, admittedly one-sided. I don't think anybody disagrees with that. Separation of powers is normally a question of law, but yet we have an evidentiary record on that third prong, interference. What does that look like, standard of review wise, if we were to reach it?
Right, well, the standard review on TI, it's abuse of discretion. Court can look at legal questions de novo, and we're not going to argue you shouldn't look at the other ones de novo. But mixed question of facts, it's there's a abuse of discretion, sufficiency of the evidence. So I think it's this mixed question, and if the court agrees with me that on interference, that goes into like an as applied, it interferes in fact, then I think that's where you would say, well, we have a finding now. We should let them go to the full trial on the merits, and we'll review that point after we're done. Because I think how you would do that. They might disagree with that, but I think that's right. Unless there's any questions, I would like to make a concluding statement.
Sure.
This is an important case. It's not based on technicalities. It's not based on politics. This regulatory scheme, as we discussed, is causing real harm, invasive oversight, causing district and county attorneys to hand over case files and victim information. If the legislature had intended for the single sentence to be a capacious grant of rulemaking authority, it would have done so. It would have said so clearly. In the words of Justice Scalia, Congress or the legislature does not hide elephants in mouse holes. I think that's what this case is about. We ask the court to affirm. Authority is the simplest path. Thank you.
Thank you, Mr. Sneed. Mr. Pfeiffer?
Good afternoon. May it please the court. I am Justin Pfeiffer, and for Brian Middleton. Middleton agrees. In line with the separation of powers and exclusive legislative authority, there must be a duly enacted statute that provides the Attorney General with authority to request materials from prosecuting attorneys. That can be by rulemaking or by specific duty. In the 89th legislature, the two exhibits that Mr. Steed mentioned, exhibits C and D, conclusively refute the Attorney General's assertion that 41006 is a blank check. Otherwise, these new provisions would be completely superfluous. Last Friday, in fact, the governor signed SB 12 at the second called session, which along with the briefed HB 45 strictly connect the Attorney General's authority to request non-public case information to the Attorney General's, what is their purported original prosecutorial authority, meaning that he doesn't have to ask the permission of the district attorney to assist. He can initiate charges on his own, which obviously runs afoul of Stevens. In other words, the jurisdiction for human trafficking matters and election matters, those are the limits. If 41006 is a capacious grant of authority, then new 402-102B, which is the human trafficking ability for the Attorney General to request those case files for matters he's prosecuting, then that section wouldn't have any meaning at all if the Attorney General could use 41006 to obtain the exact same materials. So while the Attorney General is correct that this matter does not raise the exact question as the primary constitutional holding in Stevens, it does raise the statutory holding there. The Court of Criminal Appeals still corrected the first court's improper application of the rules of statutory construction, which are applicable here as to the non-public information for pending matters, because of the fact that it's tied to those jurisdictional provisions. And that's in C and D. What it is basically the second section has a section, a little subsection B that refers back to the first section. These are new subchapters D and E in the government code, completely new subchapters that heretofore have not been in there.
It's 25 words or less. Time's up. You got 25 words.
I appreciate that. So yeah, so if you have to leave it to the legislative authority, and can only do so with specific grants, then that should be the end of the inquiry as to the amount of, as to the level of authority that 41006 provides. Thank you, Your Honors.
Thank you, Mr. Stein. rebuttal. Mr. Cole?
Thank you, Mr. Chief Justice, and I'd like to make 3 points if I can in rebuttal. One related to the meaning of the statute, a second about separation of powers, and if there's time, I'll touch non-delegation briefly. On the meaning of the statute, I want to seize on a striking concession by my friend on the other side. He said it's hard to find a middle ground in this statute. He basically concedes that under their view of the statute, it does nothing. Both sides of that middle, either it does something or it does nothing. The canon against ineffectiveness, the canon against surplusage, the canon against destitute, all counsel in favor of a reading of the statute that gives it meaning. I'll turn to the separation of powers standard if I can. Justice Field, Justice Ferris, you asked about this question of degree. What do we do there? Is it a question of mixed fact and law? It is a question of degree, but the legal standard is set by Webster and by In re House, by the Supreme Court. The question is not whether there's some sort of intrusion or sort of burden on one branch. The question is whether the exercise of power by one branch impairs or negates or the core powers, the exercise of the core powers of the other. If they're right that this information reporting statute rises to a separation of powers clause violation, then I don't see how the Public Information Act is constitutional because it imposes similar burdens. You'll note also that under the Public Information Act, they routinely submit to the Open Records Division of the Office of the Attorney General case files for consideration about whether certain information in there is protected from disclosure. If that's a separation, if this is a separation of powers clause violation, again, sharing information intergovernmentally, then it's not clear to me how that could be constitutional.
While you're on separation of powers,
Sure.
why isn't the Oversight Committee a Webster problem?
Well, because the problem in Webster, I'm glad you asked about that because I hope to hit Webster. Well, the problem in Webster was that the state bar was attempting to discipline the Attorney General and the First Assistant, take his law license. The Oversight Committee is not imposing discipline on the prosecutors. They can request case files, they can issue notices of overdue reports. There's nothing in these rules about disciplining them. We could put the Coranto thing to one side because, again, it's a separate statute, Chapter 66, that allows him to do that. But the Oversight Committee is just a collection of 3 employees in the Office of the Attorney General. There's nowhere in the rules that the Oversight Committee is attempting to do essentially what the State Bar was doing in Webster, which was disciplining the Attorney General for particular representations he made in an original action filed in the United States Supreme Court. The Supreme Court said in that case that's functionally telling the Attorney General what his down to the word choice in his pleadings, what he could include there. And there was a century of case law in that case that supported the Attorney General's authority to decide on the facts and the law and represent the state in the court. So there is nothing, Justice Field, in this case that's remotely akin to what the State Bar was doing in Webster. Again, this goes to the point they sort of make these arguments about regulation, but really, again, this is an information sharing requirement. We're not telling them how to prosecute cases. We're not telling them they should indict this type of case or that type of case. They should appeal this. They should cross-examine this witness in a certain way. This is a requirement that says, give us this information that the legislature has empowered us to have. I will briefly touch on the non-delegation point. The main line there is I don't think the court needs to reach it. It wasn't a ground for the trial court's temporary injunction, and as the Supreme Court colorfully has said, appellate courts are courts of review, not first view, so I think you don't have to reach that issue. If you do, I'd point you to City of Houston versus Houston Professional Firefighters case from the Supreme Court 2 terms ago. There the court said they used the non-delegation doctrine sparingly when, in Justice Cardozo's words, it's delegation run riot. The court has said it's upheld standards which are quite broad. The example they gave, a delegation of authority to the Railroad Commission to, quote, prevent waste and promote conservation. Pretty broad. This statute falls well within that sphere of breadth, and so there's no non-delegation clause problem here. Again, we think the court should reverse on the grounds that there's no probable right to relief. There is rulemaking authority here. It's at least implied, and I think that probably is the most straightforward way to resolve that. The rules fall within the scope of the statute, and there's no APA or separation of powers clause problem here. If there are no further questions, I'll yield the balance of my time.
Thank you, Mr. Cole.
Thank you.
Case is submitted. Marshal will adjourn the court.
All rise.